rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here in our case 1 CV 16-0583. Scott was, forgive me a moment. Yes, Scott versus NUSSBAUM. Each side will have 20 minutes to present their arguments. Apparently you may save as much time as you want for rebuttal, but you'll have to keep track of the time yourself. We're recording the argument, so when you approach the podium, please identify your client and yourself so we can keep that straight. In a few days, this argument will be on YouTube, so you'll be able to see how well you did. We've conferenced the case, we've read the briefs, we've discussed the arguments, so we're fully briefed on the issues today. So when you approach the podium, please just start right off with what you think we should know. Counsel, you may begin.
Good morning, and may it please the court. My name is Richard Treon. I represent the plaintiffs' appellants, and I know that you indicated about reserving time. We could choose however much you want. I would try to save 5 for rebuttal, but I know how that works. In any event, we presented you with some very confusing facts in this case, and as it arises out of 3 different cases, Scott 1, Scott 2, and Scott 3.
I'll start out. I understand your arguments regarding claim preclusion. My question is that the allegation here is legal malpractice with the idea that the case was not adequately presented in the previous case. So if that means that the argument would be that Scott did not have a full and fair opportunity to present his claims in the previous proceeding. What's your view on that?
Your Honor, my view is that the basis for the appeal and Judge Anderson's decision in applying collateral estoppel was that because the issue of causation of damages, as it might relate ultimately to the underlying legal malpractice case, has supposedly been decided by Judge Rea in Scott 2, he was therefore foreclosed in Scott 3, and as a matter of law, then plaintiffs got a court because they couldn't prove damages in their legal malpractice case, having already had that decided against them.
But couldn't the lack of sufficient proof of causation be because the attorney committed malpractice?
Your Honor, the malpractice actually occurred in Scott 1, and in Scott 2, the issue, as it was presented to Judge Rea, had to do with whether or not he was going to...
Scott 2 is Judge Anderson, I believe.
Pardon me?
Scott 2 is Judge Anderson, right?
Actually, Scott 3 is Anderson, Scott 2
I'm
is
sorry,
Rea.
you're right. I'm sorry.
I told you I confused you all. Need a scorecard here. In any event, in Scott 2, Judge Rea was faced with the question of whether he was going to allow the malpractice case to proceed or whether it was foreclosed because the attorneys in Scott 1 had failed to allege, by amending the complaint, Scott's claims for fraud and intentional interference with advantageous business expectancy by the five-star developers, which issue was never raised or decided in Scott 1. So in Scott 2, Judge Ray was faced with the question, what law am I going to apply in deciding whether or not I'm going to now preclude Mr. Scott from proceeding with his case against the developers in Scott 2 because it hadn't been presented in Scott 1. Under the old restatement of judgments, the same evidence rule, if you hadn't put the evidence in the first case, then you could proceed in the second case. Under the new restatement of judgments rule, it would apply the transactional analysis test, which means that if the malpractice or the conduct arose, the fraud, I should say, in the context of the facts of the case, and it's not raised, then as a matter of law, that issue is precluded, and plaintiff cannot proceed with his malpractice claim against, plaintiffs cannot proceed with their claim against the developer defendants because...
and please correct me if I misunderstand, the claim of malpractice is that the tort claims were not brought in Scott 1 with the contract claims, correct?
Correct, Your Honor.
If because when was causation litigated on those tort claims?
Our position is that with respect to the underlying malpractice claims, causation was never litigated because the issue that was presented in Scott 2 by the developers in claiming that Scott couldn't prove, if the judge were to allow it to go forward, couldn't prove damages, was not the same issue that actually arises within the context of the legal malpractice case. In a legal malpractice case, the plaintiff's burden, of course, is to prove the case within a case. In this matter, it has to do with showing that because Mr. Scott was defrauded of his advantageous business expectancy by the developers, he was therefore then precluded from going ahead and proving his case of damages because Judge Rea basically ruled that he found issue preclusion related to the question of not raising the tort claims, and the case should have been over at that point in time, but he added at the end of his opinion a kind of catch-all. I'm also granting defendants motion for summary judgment, rating damages and statute of limitations. But the problem is that with regard to the issue that was actually tried in Scott 2, it had nothing to do with the malpractice standard for damages in a malpractice case. The standard in a malpractice case is whether or not the attorneys, because of their negligence, precluded Scott from being able to show that but for the fraud of the developers, I could have transferred this very valuable business opportunity with this trophy 120-acre property over to other clients of mine that I represented at that point in time, and we provided evidence to Judge Rea showing factually that there were people ready, willing, and able to take over that contract, but Judge Rea got confused because the developer defendants argued that the damages issue that they were facing in Scott 2 had to do with the fact that Mr. Scott was claiming he was injured by their conduct, when the truth is it was all his own fault. Mm-hmm. He let his license lapse. He didn't get a written brokerage agreement. He should not be able to recover damages. That was the causation of damages issue that was decided by Judge Ray in Scott 2. In Scott 3, Judge Anderson then held that he was going to collaterally stop Scott in Scott 3 from being able to prove damages because Judge Ray had already decided he couldn't prove his damages, not in a malpractice case per se, but in the case against the developers on a different issue. So one of the essential criteria for applying collateral estoppel is that the issue must have been tried in the action below. The causation of damages issue was never tried in Scott 2.
Well, they filed a motion for summary judgment that says, and we'll kind of keep it as simple as possible, but says you did not plead sufficient facts to show damages. Isn't that correct?
Actually, Judge, if you look at page 16 of our brief, you'll find a quotation of exactly what they said, they being the developers, about what damages they were contending was an issue, and that's where the quotation is contained. It was the sole basis for their claim of damages. At the same time, in Scott 2, we had offered evidence to Judge Rea by way of affidavit from Mr. Scott, as we did also with Judge Anderson later in Scott 3, showing that he had 3 very viable developers who were ready, willing, and able to take over this project if he had the opportunity to do so, and that's the damages evidence that he has to prove in order to complete his malpractice case. I mean, the issue of malpractice really has never been litigated because we never have gotten there.
Aren't you asking us to rethink Judge Ray on Scott 2? And that's where I'm having some difficulties, because you didn't appeal Scott 2, and we've got rulings, one of which I probably disagree with, though it's not before me, so I'm not deciding that as to whether we have the transaction test or the new evidence test under Arizona law. But you could have appealed that, and you didn't, and now you filed this new suit, and Judge Anderson comes in and goes, well, I know you're saying that there wasn't these issues, or these issues weren't really before the court and litigated, but Judge Ray had decided them. Why do we now use Scott 3 as an opportunity for us to go back and decide what was actually decided in Scott 2?
Fair question. In understanding the historical relationship of what happened, Scott 1 was over in December of 2009. In February of 2010, after I came into the case, I then found the facts that I thought supported the claim for the tort. That's when I filed Scott 2. Scott 2 was then put in abeyance by agreement of counsel until Scott 1 was decided, because, again, deciding which law the court was going to apply, whether it's going to be same evidence for transactional analysis, the case was either going to survive or it wasn't going to survive. Initially, Judge Rea denied the motion to dismiss, and then right before trial, defendants filed a summary judgment motion, and that's where the court then decided that I'm going to apply the best rule, the transactional analysis rule, and on that basis, the failure to bring the tort claims in underlying Scott 1 precluded Scott from then litigating that issue ever again vis-a-vis the developers, and so it was issue preclusion. But then he went that extra step and said, I'm also granting the other summary judgment motion, which goes to whether you properly pled and alleged. And frankly, Your Honor, from the perspective of the lawyer then that had to make a decision, this is in the record, I'm not just going outside the record, I told counsel, look, my clients would rather recover the money that they're owed from the people that hurt them, the developers. I remember you talked about that during the transcript in the oral argument before Judge Anderson. And I said to them, my client's exhausted. My client doesn't have any money to pay a lawyer, and if you want to come in now and take over this appeal and try to protect, if you think the judge is wrong in terms of this issue, of course it wasn't in their interest on the transactional analysis part of it to come in and deal with it, but on the damages issue, it was an issue that my position is they had a duty at that point to step up and try to get it turned around and demonstrate that it wasn't a valid basis for the ruling. But from my perspective on behalf of Mr. Scott, it wasn't a valid rule in any event because it never dealt with the damages issue. The causation of damages issue, the motion for summary judgment was granted on, had nothing to do with the causation of damages issue relating to the lawyer malpractice case, where with the case within a case, we have to prove that he would have, assuming they malpracticed, been able to have gotten damages against the parties in Scott 1 because of their fraud and their intentional interference with that advantageous business opportunity. So it was, we were in a damned if we do, damned if we don't position, because one of the things they were threatening with already, because by the time Scott 2 was done, it's already December of 2013, and I know they're going to try to raise a statute of limitations issue, the lawyers, which is exactly what they did. If you read Judge...
Well, is the reason that you didn't appeal, one of the reasons you didn't appeal, and I realize there's never a standalone only argument, is that the Scott 2 court was right on the statute of limitations issue. So you're faced with two bases for the ruling, and one of which there's no point in appealing.
Well, Scott 2, the issue really wasn't focused in on the statute of limitations per se. Basically, Judge Ray...
the court found that it was outside the statute.
What the judge said was, after finding a 2.5-page order saying issue preclusion controls here, and the plaintiff is precluded from going forward with his claim, that, and therefore is out of court. And oh, by the way, as to defendant's summary judgment motions on damages, on statute of limitations, and those are the two issues, that I find that I'm granting that as a matter of law.
If you cannot prove causation, and I'm just speaking hypothetically, if you cannot prove causation, no matter how bad the malpractice was, your client would lose, correct? I'm just speaking hypothetically, of course.
Your Honor, properly analyzed, stop and think what's going on here. My client hires lawyers, he gets malpracticed on in the underlying action. He then hires another lawyer.
Counsel, can you repeat what you just said? I really want to get this clear. Just start this thought over again, if you would.
Okay. In Scott 1, the lawyers malpracticed on their client, Mr. Scott, by virtue of failing to move to amend to add in the tort claims, the factual basis for which were fully developed in the depositions of the two principals of the developers. And that was before any summary judgment and motion had been filed by the developers. And it's plaintiff's position that it was malpractice on the part of the lawyers not to move to amend at that point and add the actual claims that they had, because they had no hope of winning on the claims that they brought, because they knew there was no written brokerage agreement, which is required under the law, and they knew that a critical term of that brokerage agreement in any event had never been completed, because there was never a meeting of the minds between the developer, Mr. Ayub, and Mr. Scott on how long the term is going to be.
So they could have, under your approach, they could have amended into a viable claim.
Absolutely. And that's the malpractice.
And in not doing that, the result is?
Not doing that as a result, Mr. Scott lost his claims against the developers because, as it turned out in Scott 2, Judge Reyes said that applying the transactional analysis restatement of judgment principle, you're out of court. You're done. You can't proceed with the lawyers.
By the time he gets ready to bring them, the statute of limitations is run and they can't bring them.
Right.
So it is, to use Judge Howe's expression, hypothetically it's possible for an attorney to effectively malpractice their way out of a malpractice claim.
If this court were to approve what Judge Anderson decided, that's exactly that's the kind of point where I was going to go here.
With respect, counsel, I don't think you answered my question. I'm assuming that you can prove malpractice. My question, is that if you cannot prove the underlying tort that you thought should have been brought in the first action, your client still loses, correct?
We can prove that tort. We have experts who can testify that it was malpractice on the part of the lawyers, having learned this evidence during the course of depositions, and Scott won. They should have amended the complaint and added these claims.
But you still have to prove that you would have won on the underlying tort, given that it wasn't properly brought.
That's a tribal issue of fact, and for the jury, and it wasn't even raised.
Well, couldn't if a proper motion for summary judgment was made and the evidence was such, couldn't the court properly grant summary judgment against you on that basis?
Only if they want to commit an error.
Wait, are you saying that you can never grant summary judgment on a malpractice claim?
No, I'm not saying that at all. I'm saying based on the facts of this case, at a minimum, a genuine issue of material fact is created on whether or not
Right,
the
well,
lawyers...
Judge Howe was asking a hypothetical. So if you brought a malpractice claim, and let's say that the facts are undisputed, that the lawyers didn't meet the standard of care.
Right.
But there is the factual allegations you raise with respect to the underlying claim are not sufficient to meet the threshold for summary judgment. The court could still grant summary judgment even if you showed malpractice, but you can't show that you would have won on the underlying claim.
And hypothetically, that's correct. And that takes us right back to where we started, which is Judge Anderson, because what he's saying is that I'm not going to let you... Everybody assumes there's malpractice here for purposes of discussion. They didn't file a motion for summary judgment on malpractice. They claim collateral estoppel, going back to Scott 2 and Judge Ray's decision, that he found no damages. The sole basis for Judge Anderson's decision on collateral estoppel has to do with the issue of causation of damages. And he says, because Judge Ray said, I'm granting their summary judgment on behalf of the developers on causation of damages, I'm preventing Scott from coming into this case and proving that he had damages. And the issue that was decided in Scott 2 had nothing to do with the damages that relate to the malpractice case, which
Except that the court granted their second motion for summary judgment as well, which did say you didn't meet causation.
But for collateral estoppel to apply, it has to have been the same issue. It was not the same issue. Just because you call it damages doesn't make it the same issue. You got to look at the facts. The facts that they alleged were facts relating to it's his fault. He let his license lapse. He did not have a written brokerage agreement. Therefore, he's got no damages that we're liable for. And that's the judgment that Judge Ray granted. And that's not the issue that's raised in the Scott 3.
Counsel, your time is up. We'll give you 2 minutes on rebuttal, but I have one last question.
Sure.
Would you is your argument that because of the malpractice, your client didn't have a full and fair opportunity to litigate the tort claims in the previous action?
Within the context of the malpractice case, their failure to bring the tort claims was their malpractice, and it caused Scott damages, and we offered proof in Scott 2 and in Scott 3 of the exact damages he suffered. That issue has never been decided.
Thank you. We'll add 2 minutes for rebuttal. Thank you. Counsel?
Good morning. May it please the court. My name is Allison Freeman, and I represent the appellees in this case with the exception of Jayberg and Welk. And so I will leave some time for that argument to be made. So I'll be addressing all issues that don't specifically relate to only Jayberg and Welk, and they'll do that in their argument. To answer, Judge Howe, your question about when was causation litigated as to the tort claims, that happened in Scott 2. And if we've cited in our brief the areas in the motion for summary judgment where that issue was raised, as well as I believe that the reporter's transcript from the argument is part of the record in this case too. And on page 14 and 15 of that, you can see Judge Rhea actually asking questions about causation. He says things, so what is the link, the causal link between the alleged failure to disclose the license and any damage? He asks these questions of counsel, and Mr. Scott was not able to provide evidence to support his causation claim. And so in this case, we have a legal malpractice claim.
You have a what? I'm sorry, you have a what?
A legal malpractice
Legal
claim.
malpractice, thank you.
And so we have to prove, plaintiff has to prove proximate causation. And what that means in a case like this is he has to prove what we refer to as his case within the case. He has to prove the causation element of his fraud claim and his intentional interference claim in order to bring this case against the attorney defendants here.
But your argument in your brief, in your summary judgment motion in Scott 2, and I'm not talking about the preclusion one, I'm talking about the second one that was addressed in the one line at the end of the order, goes back and forth on preclusion, law of the case. In other words, you say, for example, on page 7 of it, you say, he can't show damages because the memorandum decision, the Court of Appeals decision, conclusively establishes that he wasn't entitled to damages. Well, that's claim preclusion, even though you're now arguing it as a causation element. So help me understand how we have a clean decision, setting preclusion aside. I want a clean decision that says there was a merits-based decision that his claim could not survive.
Understood. So when the issue of causation was briefed in Scott 2, that's what you're asking about, correct? Okay,
Right.
So when the issue was briefed, basically the motion for summary judgment that was filed by Five Star in that case said the plaintiffs have provided no evidence of causation in this case. And in response, the plaintiffs did not provide any.
I'm sorry, I treated it as if it was your brief. It was
Yeah,
actually
I
someone else's.
understand.
Sorry.
In response, the plaintiff did not cure that defect. And so the issue is the only damages that were ever claimed in Scott 2 was the commission. And the commission was not recoverable per the ruling in Scott 1. It was a claim for, the commission had to, basically in Scott 1 the ruling was there has to be
For punitive damages and damages for intentional infliction of emotional distress and things like that.
in Scott 2,
Right.
and those were dismissed as well because there was no evidence to support them. In the punitive damages claim, you have to have compensatory damages to provide for a claim for punitive damages, and there just was no evidence we have to also be mindful of the time frame of that litigation. So Scott 2 was filed in 2010. And it lasted years when discovery was ongoing. Whether the parties chose to take depositions or disclose evidence or not is a separate issue. But it wasn't until December of 2013 that Judge Rea actually decided. And at that point, it's the motion for summary judgment stage. If you have evidence of damages that you can claim and that are causally related to the actions, to the claims of fraud and intentional interference, that's the time when you have to put forth your evidence. And ample opportunity was provided, argument was held. Judge Rea specifically asked the questions, what evidence do you have to support causation in this case? And there was none. And therefore, that was dismissed. And in our case, it's not like you're hearing from the plaintiffs that there's some new facts or some new allegations of causation and damages that haven't been asserted. Our facts are all exactly the same.
Could it have been because counsel was not as good as they should have been in presenting evidence of causation? Wouldn't that be part of the malpractice action?
Well, what we have to remember is that the defendants in this case were only representing the plaintiff in Scott 1. And the only claim in that case was contract, and they were asking for the commission, the almost $3 million commission, and that claim was unsuccessful. They did not assert tort claims in that case, and whether that was right or wrong or strategic, those issues aren't before the court today.
But counsel, doesn't that kind of beg the question? They end up losing the tort claims because they're outside the statute of limitations, and now you're saying they should have brought the tort claims in the first action because if they had done that, or they should have been brought in the first action because if they had, then there would have been possibly colorable causation.
I understand what you're saying, but I would correct that a little bit. So in Scott 1,
So you disagree with me? That's okay. That's okay too.
only because I want to make sure I'm not confused. So in Scott 2, the defendants in this case were not representing Mr. Scott. And I think that, I mean, there are a lot of moving parts to this case. Mr. Treon was representing Mr. Scott and Scott too. So he made the strategic decisions as far as what evidence was needed to support those tort claims. Those tort claims were decided not to be brought by my clients based on that they wouldn't be successful. And so when they were brought by Mr. Treon, whether or not he provided the information that was needed to support causation is not at issue in this case, because that was not an action from my client.
But I get a little whiplashed on that. They decided not to bring the tort claims because the tort claims wouldn't be successful, but they brought contract claims where they could prove no damages.
They brought the contract, the theory of the contract claim in Scott 1 was that there was written email correspondence back and forth between Mr. Scott and the five-star defendants that the attorney defendants argued was evidence of a written contract that should support a claim for that commission. And the court disagreed and said that those emails are not evidence of a written contract based on subsequent correspondence, based on some of the deposition testimony that came out. So the claim was ultimately unsuccessful in that case. The fact that they did not bring the tort claims in that case is because they did not think that they were viable claims. But again, that issue is not before us. But we do know this because when the tort claims were brought in Scott 2, they were dismissed because for lack of causation, because there was no causal link to a claim for damages.
I have and this goes back to the question I asked earlier. In reading through it, and I probably have spent as much time reading through the pleadings and transcripts in this case as just about any case I've had in my short time up here on the bench, I have a hard time finding a ruling, dispositive ruling from the trial court that isn't in some part, in 2, that isn't in some part tainted by the preclusive effect of Scott 1. And then we now move to Scott 3, and the Judge Anderson finds that the preclusive effect of Scott 2 precludes, on the damages issue, precludes the malpractice litigation. Why isn't, because of the malpractice allegation, why shouldn't the judge be looking and say, now clean from any preclusion from Scott 1, we look at whether you've stated a claim, have sufficient evidence to pass summary judgment standard, and determine then, setting aside all the taint from Scott 1 that bled into Scott 2. Why wouldn't that be the answer for the trial court?
2 reasons, and one is some of the tainting from Scott 1 is the reason causation fails. The court found that you cannot bring a contract claim to recover these damages, but in doing that, it cited the statutory precedent that says you are legally not allowed to recover this money. And so the statutes that govern the relationship between those parties, which I can cite for the court if that's helpful, basically say that it's illegal for a sales agent it doesn't have their license hooked up with a broker to enter an agreement where they get to have a commission from a real estate sale. The commission has to, per statute, go to the broker. And then the real estate agent can get their commission. And so there is no avenue to Mr. Scott recovering that commission. So the next question is, well, can you bring a tort claim to recover some other damages for the time that you spent or as Mr. Tran was saying, these other people that what you could have contracted with? Sure, but no evidence was provided to Judge Rio to support those claims. There was nothing in the record to support any other theory of damages except for I lost my commission. And I lost my commission in Scott 1 was held to be that you cannot get that commission because you did not go through what was required to form a legal contract.
Counsel, that he presented evidence of potential other buyers that he could have sold this deal to.
That issue is discussed in the argument to Judge Rea, that there is no evidence that was actually presented to the court in deposition testimony or emails from something that could actually support a claim for damages. Because think about what that allegation is. That's the allegation that someone else was going to buy this $80 million property. That requires a lot of evidence to support. You have to show that they actually had the funds to acquire it, that was going to happen, that it gets over that mound of speculation. So to provide absolutely nothing but words of counsel to support that damages claim, Judge Rea properly found that wasn't going to satisfy what that court required to prove causation and damages.
So, is your argument that the malpractice claim fails because they couldn't prove the underlying case within a case, or are you also relying on claim preclusion?
Your Honor, the issue on appeal is issue preclusion. So in other words, that Judge Rhea decided that issue. There is no causation. You cannot satisfy your claims of fraud and intentional interference against the 5-star defendants, and that is a required element of the attorney malpractice claim. And because that required element was already decided by Judge Rhea, it cannot be relitigated. And so that's the argument. But in addition, you will see if you read the motions for summary judgment that were filed in the underlying case, we obviously will additionally argue, or have additionally argued, that at this point they haven't satisfied causation again, but we don't even get there. And Judge Anderson didn't get there because he's relying on the doctrine of collateral estoppel, which all 4 elements in this case are satisfied, to appropriately say Judge Rhea's decision on causation stands because it was actually litigated. It was full. Plaintiffs had a full and fair opportunity to appeal that if they chose to. It was a valid and final decision, and the resolution of the issue was essential to the decision, and that's the 4 elements.
How do you say it's essential? We have a judge in Scott 2 who said all your claims are precluded, and statute of limitations, and can't show damages. Which one is the essential ruling for us?
If you look at the way that the restatement talks about essential, counsel talk about it differently in the briefs, but essential as talked about in the restatement of comment H and comment J, it talks about what essential means. And it says if it's not, it can't be dicta, and it can't be something you can't appeal. That's what it's talking about when it uses the word essential. And so one of the issues for this court to decide, and I'll try to finish this quickly so counsel can have some time, what do we do with I? And it's an issue of Judge Anderson decided I didn't change it here because those 4 elements were satisfied. That's the what Arizona requires for collateral estoppel. They were all satisfied here, and so that's what should apply. And if you read in section I, it does state it might be argued that the judgment should be conclusive with respect to both issues, which now we have 3 different issues it was conclusive about. The matter has presumably been fully litigated and fairly decided. The determination does support and is in itself sufficient to support the judgment for the prevailing party, and the losing party is in a position to seek reversal of the determination from an appellate court. And later on, this is also comment I, there may be causes where, despite these considerations, which are some of the things that the court can consider when you have these alternative independent rulings, the balance tips in favor of preclusion because of the fullness with which the issue is litigated and decided in the first action. And here we have 2 years of litigation, we have summary judgment motions, we have a hearing before the court, and we have Judge Rhea's decision finding that there was no causation. This is a case where that issue was fully litigated and there was an opportunity to appeal that was not taken.
But doesn't comment I also say if the judgment of a court of first instance is based on a determination of 2 issues, either of which standing independently would be sufficient to support the result, the judgment is not conclusive with respect to either issue standing alone?
It does, Your Honor. And then it says that's not for every case.
So you would ask us to find an exception to the exception?
Comment I says some cases this is appropriate and some it's not. It's never been applied in Arizona before. And in this case, where there was a full and fair opportunity to litigate causation, and it was fully and fairly litigated, all evidence...
You can see that the majority of the discussion in Scott 2 and in Scott 3 was based upon preclusion, and these other things were kind of secondary issues. Even though they were litigated, they weren't the primary focus of anybody's litigation below?
Your Honor, only by quantity. Only because it was a new issue to Judge Rhea and he was trying to make a decision that was difficult for him. Not because it stood out anymore or was any more clear. If anything, I would say it's more clear on the record that there was absolutely no evidence to support causation. There was very little talked about in oral argument because plaintiff's attorney did not support evidence to support causation. And for that reason, it may be smaller as far as the amount of paper it takes up, but as far as but that doesn't speak to the confidence into the decision or the amount of thought that Judge Rea put into deciding that there was no causation. And unless there's other questions, I'd like to leave some time for my co-counsel.
Thank you, counsel.
Good morning. May it please the court. My name is David Farron. I'm here on behalf of Jayberg Wilk, who is the second appellee in this case. Your Honor, I really don't think I need to say a whole lot more than we said in our briefs. That is, regardless of what you think about the causation issue, regardless of what you think about the collateral estoppel issue, it's absolutely clear that the actionable claim of negligence brought in this case had nothing to do with the initial representation of Mr. Scott by Mr. Nussbaum when he was with Jayberg Wilk. The plaintiff repeats over and over again in his briefs and below and here today in this court that he's not, well, I can quote him directly from his response to the motion for summary judgment in the trial court. While the plaintiffs do contend that defendants were negligent in filing the contract claims in Scott 1, we do not contend that this was the actionable negligence upon which plaintiff's case is based. They make it clear, and they've admitted several times, that the actionable claim, the only actionable claim of negligence they make in this case is failure to amend. It's called the failure to amend claim. That is, once Mr. Ayub and Schmidt were deposed by Mr. Nussbaum in May of 2009, it came to the plaintiff's attention for the first time that he had a possible fraud claim. Whether that's true or not is another issue. But that's where the failure to amend at that time claim comes in. And again, it's the only actionable negligence claim that the plaintiff says he has brought in this case. Well, the problem is, from the plaintiff's standpoint, is that Jayberg and Wilk was no longer associated with Mr. Nussbaum at the time of those depositions. It's undisputed on the record that Nussbaum and Gillis left Jayberg and Wilk from their own law firm some 8 months before those depositions were taken. So there's no vicarious liability. You can't include Jayberg and Wilk in the net of malpractice when there's no vicarious liability. And you don't have vicarious liability when someone is not your employee or servant. That's a matter of law. So regardless of what you think about the rest of the case, it's clear that the admissions of the plaintiff, both in the record below and before this court today, is that his actionable claim of negligence is that Nussbaum and Gillis failed to amend their complaint when they discovered in the depositions in May of 2009 that they had a possible fraud claim or interference claim. Again, Nussbaum and Gillis, undisputed, were not with Jayberg Wilk at the time. Jayberg and Wilk deserved to be out of this case for that separate reason. And that's what Judge Anderson ruled. He granted summary judgment to both Gillis and Nussbaum and to Jayberg Wilk. We litigated the issue below in our briefs. You can read the briefs and the response and reply. And the fact that Judge Anderson chose not to discuss the issue in his order doesn't mean that he didn't rule in our favor. He did. He granted summary judgment, and the law is very clear that this court can affirm that judgment based on any basis in the record that's apparent from the record. And we ask the court to do that. Any questions?
Thank you.
Thank you, counsel.
Thank you.
Mr. Trina?
Your Honor, unless the court has some questions, I don't have anything to add. I think the matter has been fully briefed, and I appreciate, as I said at the outset, it's confused and confusing. I hope it's not still that, but if there's any question I can answer for any judge, I'd be happy to try to.
Could you respond to Mr. Cohen's comments?
Your Honor, the issue of whether or not Jayberg and Wilk, a law firm in which Mr. Nussbaum and Gillis were both partners at the time that they undertook the representation of Mr. Scott, beginning in March of 2007, and they were still at the law firm in August of 2007 when the lawsuit was brought in the Jayberg and Wilk's name. they stayed on the case. We don't really know when. They no longer were with the law firm. But the issue with regard to this actionable negligence reference had to do with the fact that at that point, NUSSBAUM was the only party that made a motion for summary judgment. And we pointed out that his negligence was the actionable negligence related to his failure to amend the complaint. That didn't address the issue of whether or not there was malpractice in the beginning, as there was in failing to raise the issues relating to the conduct of the 5-star developers as related to.
Refresh me, does your complaint allege failure to amend, or does it allege failure to file the proper lawsuit at the beginning?
It's broad enough to incorporate both, Your Honor, but the issue as to why Jayberg and Wilk is involved is, number one, because this wasn't really litigated below and there's no record on it, and number two, it's because their partner represented my client and malpracticed on him from the beginning. And the beginning included a period of time that they were working for Jayberg and Wilk. And under principles of respondeat superior, the law firm is liable for the negligence of the lawyer. It's that simple.
Thank you, counsel.
Thank you.
We appreciate the arguments of counsel. We'll take this matter under advisement and issue a ruling in due course. If counsel in the next case are present, we will stay on the bench while counsel approaches. We'll stay in recess. Thank you.